Hi, my name is David Taylor. I'm an estate planning attorney here in Twin Falls, and I'm doing a presentation today on probate and give you a little bit more on what that is. And just a quick disclaimer, this is not meant to be legal advice. Legal advice comes from you interacting with an attorney. And so just keep that in mind. This is just meant to be informative. A little bit about me is I grew up in the Boise area. Was married here in Twin Falls, so Twin Falls kind of like a second home. But when I first started doing estate planning, which is primarily wills, trust, planning for things like that, the attorney who trained me handed me a bunch of probate cases, and I thought, I wanted to learn estate planning, and he said, "This is how you learn estate planning is by doing probate." And this will probably make sense in a little bit, but that was how I was first introduced into the world of probate. And one quick thing I'll say is probate is not necessarily bad or evil. It's just one of those things where it is what it is. And usually the things that make probate bad or evil are some of the parties who are interacting with the probate proceeding. And that might make sense here in a little bit, but that's just kind of a little bit about me. Is I like doing estate planning, and to me, estate planning is not just drafting wills and trusts; it's also doing probate representation and helping things get settled when someone has passed away. So this is meant for one or two types of people. Perhaps you're here, sadly, because you've experienced the death of a loved one and you need more information on what's going to happen, and this is what this presentation is for. Or you have, maybe you're just interested in learning what probate is. Probate is. Maybe you've heard the word, and maybe you have some questions about it. And that's what this is for. So, what is probate? I put the lengthy definition there. Really, what it is, it's winding up someone's affairs after they passed away, and a court of law oversees that process. Why? That's what we have. It's important to make sure that when someone passes away, that all the debts are settled, that all the remaining money goes to the right people. And by default, unless you plan otherwise, then the court oversees the process. That's basically what probate is. No matter what, when someone passes away, we're going to have to pay the debts and get the money to the right people. And probate's just that process of making sure that it gets done right. So that's what probate is. It's required if you either owned real property or if you had over $100,000 in assets. Real important to point out that if you own, or the person who passed away owned real property, doesn't matter if it's a square acre of land over in Kimberly, you've got to go through probate. Or if you had more than $100,000 in probatable assets, then you also need to go to probate. It's not both. You just need one or the other to be there. So that's when we have to go through probate by law. Let me explain a little bit about the basic framework. So again, this is a court proceeding. So that's what I'm going to talk about. This is what Idaho law asks us to do. Is the first thing it asks us to do is to determine who's going to be the personal representative. You might have also heard this person referred to as the executor, administrator, whatever it is. There's one person, typically one person, who is running the show. And this person can do practically anything that the person who passed away could. They can enter into contracts, they can write checks, they can wind up the affairs, pay debts, things like that, give property to who they're supposed to. That's that person's job, is to do all of these things. And it's kind of a process to get the personal representative appointed, unless there was a will. We'll talk about that in just a second. The first thing the personal representative has to do is file what's called an inventory with the court. And that means that we have to let people know what's at stake. What people? Well, probate is primarily for two parties, the creditors and the beneficiaries. Now, just one quick caveat. A lot of people come in my office say, yeah, but I don't have any creditors, or the person who passed away didn't have any creditors. I'm with you, but again, this is the plan by default, is we got to go through this and notify creditors, known or unknown, that the person has passed away. And I'm going to talk about that in just a quick second too. But, the whole point of the inventory is a lot of people have some hesitation with this, because you're putting assets on display, and people will know, what the person who passed away, what they're worth. But that's the process. We got to let the creditors, we got to let the beneficiaries know what's at stake. So for the creditors, we have a process, kind of archaic, but we put something in the newspaper. It's called a notice to creditors. And when we do that, that basically tells all creditors, known or unknown, that they have 120 days to tell us that there's an outstanding debt. And why do we do that? Because otherwise, this could take years to settle the affairs and wait for the creditors. So instead, we say, nope, you have 120 days to make it known. Once everything is done, so once everything is administered, you pay off all the debt, and you sell all the property and everything like that, then you have to, of course, distribute the property, and we call that the residuary. That's a fancy legal term for whatever's left. But the main thing is we have to wait 6 months for that to happen. Why? We have to allow 6 months for the creditors or for the beneficiaries to chime in and say, no, we don't like how this is running. What you're still going to find is the plan by default is kind of a one size fits almost no one plan. But that's what we got, because we don't know people's families. We don't know what people had or didn't. So we just have to put a plan in place, and this is it, unless you do some planning otherwise. And so one thing I want to make sure is known is, in case the person who passed away had a will, it's a little bit different. So if you do a will, then the will directs the probate court. Now, one quick thing is, one of the biggest misconceptions out there is that a will avoids probate. A will does not avoid probate. It makes it simpler. And actually, a will is technically a court document. So if you have a will, then you can determine two things that happen in probate courts, or if the person passed away had a will. Two things that are going to be governed by that will is, number one, who is going to be the personal representative? So maybe that person, whoever did a will, said, yeah, I don't want this person to be the personal representative, or something like that, or my kids are probably going to fight over it, so this is who I want it to be. That's the first thing you do in a will. The second thing is, who's going to get my property when I pass away? So going back again real quick, there is a plan for both of these things. And without making a will, then you're subject to what the laws of Idaho say, to what the government says. So many people do a will because they don't want to do what Idaho says, and they want to make things easier. So if the person passed away, if they had a will, that's what happens. It does not avoid probate. Some frequently asked questions: is an attorney required? No. Well, there's no law that says an attorney is required. Probate is basically a bunch of court paperwork. You certainly could do it on your own. I'll give you a few tips on that. Typically, people hire me just to do the court paperwork. I'll give them some advice on administering the estate. But in many cases, if I give a checklist, then people can just go on their own and do things. And you don't have to have an attorney. How much does it cost to go through probate? Now, I'm one of the few attorneys, I don't like billing by the hour. So, but I can still tell you an average. Sometimes a probate case starts at $750 for that's more like the do-it-yourselfer who just needs a little guidance and they'll do all the work, to $3,500 for someone who really wants an attorney to do everything as much as possible, save them some time. Most cases that I've seen end up around $2,000, somewhere in the middle. And that's usually someone who just hires the attorney to do the court paperwork. So it's going to be a little bit different depending on what you want the attorney to do or not do. How long does it take? 6 months at least. And is probate really that bad? Based upon what I explained, it's not. Again, it's not evil. It is, in my opinion, unnecessary. There is a way to plan to avoid probate through a trust-based plan. That's pretty much what a trust does. But no, I don't think it's necessarily evil. It's just one of those where it is what it is, and we'll help you navigate through it. So for those who have experienced the death of a loved one, I am sorry. I try and do everything I can to accommodate for everyone's situation. People have different kinds of assets and things like that. But if you call us or email us at the information provided here, we'll provide you with a free checklist. If you wanted to come in for a fee, you can schedule what's called a probate navigation consultation. Again, it just depends on how much work you're willing to do. There are ways you can do it on your own without the assistance of an attorney. For those of you who are watching this who want to do an estate plan, learn more about probate, how you can avoid it, this is my contact information as well. And you can schedule a family asset protection meeting. So thank you for attending again. Like I said, very basic, but I just hope this gives you some direction. Do feel free to call me. We don't believe in surprise billing, so call my office if you have any questions, and we'll see what we can do to help. Thank you.